Good morning, students. Welcome to my class. I am Dr. D. Anita Kumari, Associate Professor of School of Management Studies, Wales Institute of Science, Technology and Advanced Studies, Chennai. In today's class, we are going to discuss about discharge of contract under the Indian Contract Act 1872 and breach of contract. So already we have discussed about different types of contract, classification of contract, what is contract, okay, what is called quasi-contract, what are the rules to be followed when you enter in a contract, all the things we have discussed. In this two topic, we are going to discuss the important terms. Okay, first let us learn about discharge of contract. So before starting this topic, let's see the objectives of this unit. To state the meaning of discharge of contract, to know the various remedies available under the breach of contract, to state the types of breach of contract, to understand various classification of discharge of contract, to avoid the rules related to the discharge and breach of contract. Meaning of discharge of contract. What is called discharge? Discharge of contract refers to the situation when a contractual relationship between the parties comes to an end. When both the parties enter in a contract, due to some reason, if the contract comes to end, that is called discharge of contract. So in this topic, we are going to see in what are all the way the agency, what are all the way the contract will comes to end. Okay. Example, A fixed a party at her house and hired some dancer to perform and promising to pay them their money. The dancer arrived at the gathering to perform. A pay their payment in accordance with the contract provisions. Here, the performance of the dancer will amount to be the discharge of contract since the terms of agreement have been completed. The dancer failure to perform will result in the contract of termination. So what happened? So here one person hired the dancer for the party, but the particular dancer was refused to perform her promise. Because of that, the contract comes to end. Okay, so what do you mean by discharge? The termination. Termination. What are the way the contract will comes to end? When an agreement which was binding on the parties to it ceased to bind them, the contract is said to be discharged. A contract may be discharged in the following ways. So this is the different mode of discharge of contract. The mode of discharge of contract is classified under 6 category: the by performance, by impossibility of performance, by lapse of time, by breach of contract, by mutual agreement, by operation of law. By operation of law, there are two types of discharge of contract: by actual, by attempted. By impossibility of performance is there. Then by breach of contract, there are two types of breach of contract is available: actual and anticipatory. By mutual agreement, under the discharge of mutual agreement, novation, rescission, alteration, remission, waiver, merger. Whereas under the by operation of law, discharge of contract, death, merger, insolvency, unauthorized alteration. So these are all the different mode of discharge of contract. Let's see one by one. First, discharge of contract by performance. Under a contract, each party is bound to perform his part of the obligation. After the parties have made the due performance of the contract, their liability under the contract comes to end. In such a case, the contract is said to be discharged by performance. See, when both the parties enter in a contract, they have to fulfill their respective promise. If any one party or if both the parties are fail to perform their respective promise, then automatically this contract will discharge. By performance, there are two types of discharge of contract by the performance. One is actual performance, or another one is attempted performance or tender. Actual performance is when both the parties perform their promise. That means we should not, this discharge of contract, we should not see from negative way. Okay. What do you mean by discharge of contract? In what are all the way the contract will comes to end. So under the performance, in the first type, actual performance, in the sense when both the parties have completed their respective promise or respective obligation, automatically the contract will comes to end. For example, I am appointing one person to transfer one goods from this place to another place. For that purpose, I agree to pay some part of money. In this situation, he has transferred the goods. The work what he has done, for that I have given a money. Automatically, the contract will comes to end. That is called actual performance. So what is the concept? When both the parties have performed their respective promise, that is called actual performance. Attempted performance or tender. Only an offer to perform the obligation under the contract. So what do you mean attempted performance? In this case, again, same example. I have appointed one person to transfer my goods from one place to another person, another from one place to another place. But the particular person has not started his performance. Even I have not handed over the goods to him. Okay, this is a case. This is called attempted performance. Only the proposal made, when the proposal made, but the action is not done. That is called attempted performance at tender. One more example I can give you. I am having a car. I want to resell my car. So I asked one of my friend, I have a car. I want to resell it for 2 lakh rupees. Are you interested? She said, okay, I'm interested. Let's see by next week. But after a week, there is no conversation about the car. So only the proposal has made, but there is no action. That is called attempted performance. Automatically, there is no contract in this place. Discharge by mutual consent and agreement or agreement. So what do you mean by discharge by mutual consent or agreement? If all the parties to a contract mutually agree to replace the contract with a new one or annual or remit or alter, then it leads to a discharge on original contract due to the mutual agreement. So what do you mean by discharge by mutual consent? In the sense when both the party mutually, voluntarily, they agree to bring the contest to end. That is called discharge by mutual consent. Okay. Example, Peter owes rupees 1 lakh to John and agreed to repay it within a year. They document the debt under a contract. Subsequently, he lost his job and requests John to accept rupees 75,000 as a final settlement of the loan. John agrees and they make a contract to the effect. The discharge of the original contract due to the mutual consent. See, again, I'm telling you students, discharge of contract in the sense, in what are all the way the contract is coming to end. Okay. So in this example, the particular person, Peter, he has given 1 lakh rupees to John. John promised to Peter that within a year I will repay the particular amount. But within a year, he lost his job. He is not in a position to pay money. So he requested Peter, I'm sorry, Peter, I'm not in a position to give you the full amounts due to my loss of job. So can you able to accept 75,000 and let us complete this contract? Even he said, okay, let us agree. So mutually, when both the parties are bringing the contest to end, that is called as discharge of mutual consent. This discharge by mutual consent or agreement classified in the following way: novation, rescission, alteration, remission, waiver, and merger. Let me tell you some small key points about these points. Novation means alteration. If you are doing any alteration in the present contract and bringing the contract to the end, that is called as novation. Whereas rescission means cancellation. Okay. Rescission means what? Cancellation. When both the party or any one party cancelling their respective promise, that is called as rescission. Whereas alteration in the sense, here the whole concept of the contract itself will change automatically. Because of that, the contract will comes to end. The contract will discharge. Okay. Then remission means giving up. Giving up. Any one parties in a contract will give up in such a way the contract will comes to end. That is called remission. Then what is called waiver? Waiver in the sense due to the relationship, maybe husband and wife relationship, due to some blood relationship, sometime the contract will comes to end. Let's see, we are going to see in detail about all the points, but anyhow, I'm giving you some key points about in each and every point so that it will be helpful for you to study at the time of your examination too. Then merger. What is called merger? When the two parties enter in a contract, when the two parties become as a one party, that is called as a merger. We will see in detail. First one, discharge by mutual consent. Under that, first one is novation. So what is called novation? As I told you, novation means doing some changes. That means some substitute in a contract. Okay. When a new contract is substituted for existing one or between the same parties. When a new contract is substituted for an existing one between one of the party or a third party. So that is called novation. Let's see with some example. So novation can be done in a two-way. That means novation by change in the subject matter or novation changes in the parties. Okay, so novation means what? Sort of alteration. See, whenever the contract is created between two parties, the sometime mutually they will bring some changes. The changes might be due to the subject matter or due to some changes in the parties of the contract. Let's see in detail. See this, changes in the terms of the contract. A owes, that means A owes means what? A needs to pay rupees 10,000 to B. A enter into agreement with B and gives B a mortgage of his estate for 5,000 rupees in a place of debt for 10,000 rupees. This is a new contract and executes the old one. So can you able to understand? As I already told you, what do you mean novation? Novation means alteration. In the existing contract, you will do mutually, both the parties will be doing some alteration in the either subject matter or in the parties. In the subject matter, what they're doing is, I have given 10,000. I am A. For example, I am A. I have given 10,000 to B. Okay. So B has to give me 10,000 rupees. But due to some reason, he is not in a position to give 10,000 rupees. So what he is doing, he is giving some of his one of the property, which is also the cost of, maybe 5,000. He has given a 5,000 in a cash and remaining 5,000. For remaining 5,000, he has given some goods or some property, whatever it is. Then I said, okay, I accepted. So this is called changes in the subject matter. Do you understand? So changes in the subject matter in the sense when the existing contract itself is getting altered, changes, that is called changes in the subject matter. That is called novation too. Then changes in the parties to your contract. So here in this case, A means, for example, take Anita. Okay, I have given money to B. Okay, B, he has to return back the money. I have given 10,000 rupees to B. B has to give me a 10,000 rupees. But B is not in a position to return back the money. So what happened? B's friend C entering in the contract and accepting this contract and giving the amount whatever he had to pay to me. That is called alteration or changes in the parties to the contract. In such a way, contract is coming to end. So what is the contract? I have given 10,000 to B. B, he has to give me 10,000. In case if he would have given a 10,000, the contract might be coming to end. But he is not in a position to give a 10,000 rupees. So his friend C entering in a contract and giving a money. I'm accepting it. I'm accepting because I need a money. Okay, I given a money, I need a money. That's it. So whoever is giving, whether it's a B friend, B's friend or B, I don't want to bother about it, right? So now I accepted this. In such a way, the contract comes to end. So novation means, again, I'm telling you, changes or substitution in the existing contract. That substitution is done in a two-way, either changes in the subject matter or changes in the alteration in the parties. Discharge by mutual consent. Rescission, what I told you, rescission means what? Cancellation. The cancellation also could be done based on two-way, either by mutual consent. When one party failed to perform the contract, the other party also could resign, cancel the contract without the fear of the claim of the compensation. For example, one more example. I want to sell a car. The car is again 2 lakh rupees. My friend, initially she is accepted. And she said, okay, I will buy a car. But later on, she is not ready to give her 2 lakh rupees. So in this case, example, she is not ready. When one party failed to perform his respective promise, then even I'm also canceling the contract. Do you understand? When any one party or both the party are canceling their respective promise, that is called rescission. So here I have given an example here. A promised to paint a picture for B. B afterwards forbids him to do so. A is no longer bound to perform the promise. Remission of performance. What do you mean remission? Rescission means cancellation, whereas remission means performance. So what is called remission? Giving up. So dispense. The section permit a party who is entitled to receive the enter in a performance of the contract to giving out with a responsibility. For example, I'll give you some with example. See here, I have given 5,000 rupees to B. Okay, so I have given a 6 month time of 6 month time to return back the 5,000, but he is very poor basically. Okay, so he's not in a position to give 5,000. He has given only 2,000 rupees to me, return back to me. He has returned only 2,000 rupees. He explained the situation too. Then what I did, mutually I agree the situation of the particular person. Then he has given only 2,000 instead of 5,000 whatever what I have given to him. Then I accepted. That is called rescission. Rescission means giving up. Okay, when both the parties or any one party is doing some adjustment or doing some compromise in terms of money, compromise in terms of change of goods, compromise in change of subject matter, compromise in change of parties in a contract. So in such a way, the contract is comes to an end. So I hope so you can understand clearly what is called rescission, what is called remission, then what is called novation. Accepting the performance from the third party. Sometime, I already told you that I have given a money to B. B has to give a money back to me, but B is not in a position to give her money. So C entered in a contract. The B's friend C entered in a contract and paid her money. In such a way, the contract is comes to end. So discharge by mutual consent, alteration. So what is called alteration? Modification of one or more terms of the contract by the mutual consent of the parties. Sometime the major modification will be done in a contract to bring it to the end. For example, A agreed to buy a car from B for rupees 1 lakh and the payment is to be made after 1 month. Later on, A requests B to accept the payment. After 2 months, B accepts the request. The original contract is discharged by mutual consent. What do you mean by this? Actually, this is a contract which is entered based on some fixed period. For example, A agreed to buy a car from B. For example, Anita. A means Anita. I am entering a contract with the B. I am handovering my car. I'm reselling my car for 1 lakh rupees. I have given a time, 6 months of time to pay money. So he has given only 50,000. He has asked time up to 6 months to pay remaining 50,000. I said, okay. Now, after 6 months also, he has not given a money. Okay. In this situation, I approached him. Even he requested me, ma'am, please kindly extend the time period for another 2 months to repay the amount for you. Whatever balance is there, I will repay you within a 2 months. Can you allow me 2 months? So in this case, okay, I accepted. So that is called alteration. Alteration is done. Modification is done in terms of a contract by mutual consent with the both the parties. So within 2 months, he has given a remaining money. Then that's all the contract comes to end. Okay. Remission means, already told you what is that. Discharge by mutual consent. Waiver. Fifth one is waiver. What is called waiver? When the parties to the contract agreed that they shall no longer be bound to be in a contract relationship. For example, this waiver mostly applicable to the relationship basis. Okay, so husband and wife, they are entering in a contract in the marriage, right? When mutually husband and wife are deciding that no way we know you, no more we no need to continue our relationship, let us divorce. Okay, so like that, when both the parties are mutually breaking the relationship, That is called waiver. Okay. A promised to paint a picture for B. B afterwards forbid him to do so. A is no longer bound to perform the promise. When one person is giving assurance, but later on, when the person is not ready to fulfill it, that is also will be coming under the waiver. Okay. Merger. So what is called merger? When the inferior right occurring to party under the contract merges into a superior right occurring to the same party. For example, A is holding a property under lease. Subsequently, he buys a property. A right as a tenant is inferior to his right as owner of the property. For example, I am leaving my home for lease purpose. Okay, I am leaving my home for lease purpose. So what happened? He is a tenant for me. So due to some emergency purpose, I need a money. For that purpose, what I have done, actually the contract is between whom? Myself and my tenant. Okay. So due to my financial problem, I would like to sell my home. So my tenant itself is agreed to buy my home. In the sense, when there is a two party, become a one party. Merger means what? Now tenant become a owner. Why? Because he bought a property. So there is no contract. Previously, there was a contract. What kind of a contract it was? I am the owner, he is a tenant. But later on, what happened? He become a owner. So automatically, the contract, the tenant and the owner contract comes to end. Okay. Now, such a way, the discharge of contract occurs. So as of now, we have discussed two types of discharge of contract. One is discharge by performance. Under that, actual performance and attempted performance. Actual means when the both the parties have completed their respective promise. That is called actual. Attempted in the sense just the proposal made, but there is no action as done. That is called attempted. Okay. Then whereas under the discharge by mutual consent, there are around 6 types we have seen. Novation, rescission, alteration, remission, and waiver and merger. Novation means changes in the subject matter, either changes in the subject matter of the contract or changes in the parties. Rescission means cancellation. Alteration means doing some modification in the existing contract. Then what you may remission? Remission means giving up. Waiver means what? When due to the when there is a relationship due to some misunderstanding, something when they decide to when they decide to uh, close the relationship, that is called waiver. Whereas merger in the sense when there is a contract between two parties, that when one party become owner and when one party become a merger, then automatically the contract will comes to one. Okay. Next, the third one is discharge by impossibility of performance. Discharge by impossibility of performance. If it is impossible for any parties to a contract to perform their obligation, then the impossibility of performance leads to discharge of contract. If the impossibility exists from the start, then it is impossibility ab initio. So what do you mean by this impossibility of performance? So what is called impossibility of performance in the sense? When at the time you enter in a contract, there might be a possibility to perform the particular contract, but due to some reasons, sometimes you could not able to execute the contract. That is called impossibility of performance. That impossibility of performance may occur due to the following reasons. Maybe distraction of the subject matter essential to the performance, and unforeseen changes in the law, declaration of war, non-existence. We can give you the live example now, right? So almost 2 to 3 years back, importing and exporting the goods to China, it was not a forbidden one. Okay, that means it is not our void valid. But after after declaration of our government, we could not able to import and export the goods to China. So that is one of the examples. Now, what is happening right now in Russia-Ukraine issue? That is also one of the examples, right? Next example, Peter entered into a contract with John to marry his sister Ovia within 1 year. However, Peter meets with an accident and becomes innocent. So the impossibility of performance leads to a discharge of contract. So what is our concept? What are all the way the contract is comes to end. So in the third section, we are seeing sometime we could not able to execute our performance. So under that first point, what? When the person itself is not there to execute it, then automatically the contract will come to end. By the impossibility of performance, there are certain types, two types. Impossibility at the time of agreement, impossibility arising subsequent to the formation of contract. So impossibility at the time of agreement, impossibility unknown to both the parties, impossibility known to parties. So under the impossibility arising subsequent to the formation of contract, under that, by the distraction of subject matter, non-existence or non-occurrence of a particular state of thing necessary for the performance, by death or disablement of the parties, subsequent illegality, and declaration of war. Let's see one by one. By impossibility of a performance, A promised to B to sell his horse on 1st June, but before the day, the horse dies. What will happen? The contract comes to end because the subject matter is no more. Then automatically the contract will come to end, right? Next, impossibility at the time of agreement. Okay. At the time when you enter in a contract itself, you comes to know that you could not able to execute it. That is called impossibility at the time of arriving at an agreement. For example, A agreed with B to discover a treasure by magic, and B agreed to pay 5,000 A for this act. It is not a valid contract. Okay, and then one magician is entering a contract with one person and saying that give me 1 crore rupees, I will give a birth to the dead body. Is it possible? No, that is called impossibility, which is not at all possible. Okay, that time itself, at the time of agreement itself, the contract is coming to end because there is no way. Okay, that is the impossibility of the performance. In such a way, the contract will come to end. Impossibility unknown to both the parties. Where the impossibility is unknown to both the parties, the contract become void when the impossibility is discovered. A contract to marry B, A contract to marry B, being already married to C, and being forbidden by law to which he is subject to practice polygamy. The contract is void. A must make a compensation to B for the loss caused and her non-performance of his promise. Here, the impossibility of a performance of the contract was known to A. A is one of the parties. We understand impossibility unknown to both the parties or any one party. So, for example, A wants to marry a girl B, okay, but B, she doesn't know that this A got already married. So, in such a way, if she comes to know that he is already married, that guy is already married in the sense, automatically the contract comes to end. Because it is impossibility. Because unless otherwise he get a proper divorce from the first wife, she could not marry with the person, right? Because she herself doesn't know that he got married. Here some fraudulent activity is going. We should understand that. That is called impossibility unknown to either both the parties or any one party. Impossibility known to the parties. Impossibly known to the party in the sense when both the parties knows very well that this contract cannot be executed. Then also they enter in a contract in the sense that contract will become discharged. Okay. For example, same thing I told you. A agreed with the B to convert copper into gold. Is it possible? So even though you give a 1 lakh rupees or 1 crore rupees, can you able to convert the copper into gold or sand into the gold, sand into the diamond? Is it possible? No. At the time of entering the contract itself, both the parties know very well that this is not a possibility. This is an impossibility of performance. Impossibility arising subsequent to the formation of contracts. Subsequent means after. That means when you enter in a contract, that time there might be a possibility to perform the contract. But due to some reason, furthermore, you could not able to continue the contract. That is called impossibility arising subsequent to the formation of a contract. For example, A, an Indian citizen, enter into a contract to supply a certain goods to B, a foreigner, at his port. Subsequently, a war was declared between two countries. Here the contract become void when the war is declared. and the parties are discharged from performing the contract, and thus the contract is discharged. So in this, we could able to understand that at the time they enter in a contract, it might be valid, but due to some reason, the contract cannot be executed further. That is called impossibility arising subsequent to the formation of a contract. Discharge by supervening impossibility, by destruction of subject matter. By destruction of subject matter, and this is for what purpose they have entered in a contract. The subject matter itself is no more, or if there is any kind of a damages, or if there is any kind of a collapse happen in the subject matter itself, automatically the contract will comes to end. For example, a music hall was agreed to let out his certain day, but before the date, it was destroyed by fire. For example, I will tell you, I am having some music hall. I'm leaving it for rental purpose. Okay, I'm leaving it for rental purpose. One person entered in a contract. He has booked the hall, that music hall on July 10th. Okay, even I got an advance, but before July 10th, some accident, fire accident happened in my music hall. What will happen? The subject matter itself is, got collapsed or destroyed something. Then automatically the contract will comes to end. So while you are free, I have mentioned some case studies here. You can see some case studies. I have mentioned here Howley versus Copland 1876 LP QB 462. So non-existence and non-occurrence of a particular state of things are necessary to perform the contract. Sometimes the contract are made on the basis of continued existence certain state of circumstance. In such case, if the state of things cease to case in charges. For example, A hired a roof from B for 2 days to witness of a coronation processing of King Edward VII. So for example, in this case, what they're trying to say, non-existence and non-occurrence of a particular state of thing in the sense, for what purpose you enter in a contract, the purpose, the main purpose itself is not valid, or it's not no more, then automatically the contract will comes to end. By death or disablement of the parties. When two parties enter in a contract, after subsequent year, if anything happens to any one party or two party, automatically the contract comes to end. For example, A promised to paint a picture for B by a certain day. A dies before the day, a contract cannot be executed. Subsequent illegality. What is called subsequent illegality? The contract that are valid at the time when they enter into contract but become unlawful due to some reasons. I already told you that. Okay, the sudden declaration of war, something happens. Okay, so these are the examples for this kind of subsequent illegality. Some examples also I have given in the slide. A sold to B a specified parcel of wheat in a warehouse. Before delivery, the wheat was requisitioned by the government under the statutory powers. The delivery being now legally impossible, the contract was discharged. Okay, it's by Shipton Anderson.com and company. Who was government by the Hindu law, who already had a wife promised to marry B. Later on, the Special Marriage Act is passed prohibiting polygamous marriage. The contract of marriage become valid. Okay, declaration of war. A contract entered into during the war with the alien enemy is void. So what is called declaration of war? I already told you, right? For example, I'm entering a contract with one person in Singapore. That time when we enter in the contract, it might be valid, but later on, due to some reason, the government is announcing war between India to Singapore, or we should not enter in a contract from here to there. In the sense, what will happen? Automatically, the contract will not be executed. Then discharge of contract will occur. By operation of law, we have seen by death, by insolvency, by merger, by unauthorized alteration of this written document. So what is called by, see, these points already we have seen, by death, insolvency, by merger. So what is called by unauthorized alteration of the terms of written document? For example, I enter in a contract with one person with help of written document. Okay, so I came to know that he has done some alteration in the written document. In the sense, automatically what will happen? The contract will comes to end. So if you are doing any kind of alteration in the bond paper and stamp paper at the time of, at the time of registering any kind of a land or a home or any kind of thing, then automatically the contract will comes to end. Discharge of contract by lapse of time. So what is called lapse of time? In case if the contract is created based on some fixed period of time, if the time is exceeds, automatically the contract will comes to end. Okay, the Limitation Act 1963 describes specified period for performance of a contract. If the promisee failed to perform and promisee failed to take up an action within a specific period, the later cannot seek a remedy through law. For example, see here, Peter take a loan from John and agree to pay installment every month for the next 5 years. However, he doesn't pay even a single installment. John called him a few times, but then he get a busy and take no action. 3 years later, he approached the court to help him to recover his money. However, the court rejects his suit since he has crossed on the time limit of 3 years to recover his debt. So what do you mean with this? When you are entering a contract with one person based on some fixed period, if within the fixed period, if you comes to know that the particular person is not repaying the money or he escaped somewhere, he's not repaying you in the sense, you can suit against the particular person, you can claim the compensation. Whereas if the contract is created based on one particular period, within the time, if he is not fulfilled, then after 2 to 3 years, if you are raising up the issue, it will not be considered as valid. Discharge of a contract by lapse of time, already we have seen this. Next, same thing. Discharge by breach of contract. So last one, discharge by breach of contract, actual breach of contract and anticipated breach of contract. What do you mean breach of contract? Where a party refuses to perform their respective promise. Here, parties at the time they enter in a contract, that time itself they will refuse to perform it. In such a way, the contract will come to end. Okay. Actual breach of contract. Actual breach of occurs when the during the performance of contract at the time when the performance of the contract due, one party either fail or refuse to perform his respective promise. For example, A agreed to deliver to B a 5 bags of sugar on 1st Jan. He fails to do so on 1st. There is a breach of contract. At the time they enter in a contract, he agrees to deliver a sugar of 5 kg on 1st, but he has not done it. That is called actual breach of contract. When the parties are not interested to perform the contract, automatically the contract will come to end. Anticipatory breach of contract. So here, he is expressing his view openly by reason that I don't want to continue this contract. That is called actual. So when the two parties in a contract openly express their refusal to perform the contract. Okay, please make a note of it. What is called actual breach of contract? When the parties, either one party or two party, refuse to perform the contract. That is called breach of contract. Under that, there are two types, actual and anticipatory. So what is called actual? Actual in the sense, when the either two parties or one party voluntarily, they will be refusing to perform such a certain performance. That is called actual. Whereas under the anticipatory breach of contract, by the way of the act, by way of their activity or performance, or by the way of their delayness, we could able to understand that he is not ready to perform the contract. For example, when a party to a contract refuses to perform his performance on before the actual time, that is called anticipatory. A contract, example, a contract to supply certain goods to be on 30th June. But before the due date of the performance of the contract on 36/11, A informed B he is not going to supply the goods. On the other hand, he is refused to do it. So these are all the examples for this. Repudiation of contract. What is called repudiation? When a party communicates his inability to perform his respective promise, that is called repudiation of contract. So that's all. The short summary of your discharge of contract. So first one, by performance, if both the parties to a contract have performed their respective promise, that is called actual. Or attempted means when one party only performed or both the party yet to perform. Under the mutual, already we have seen when both the party mutually they agree to bring the contest to end. That is called mutual, by mutual agreement. Under that, novation, alteration, rescission, remission, we have seen. Then impossibility of performance, we have seen when at the time of entering the contract itself, both the parties, they know very well it is not possible. So under that, there are two types are there. Then promissory of failing parties, we have seen by operation of law, all the things we have seen.